Thank you for joining me today. I'm Mary Fountain, an Indiana personal injury attorney. Today's video is about comparative fault, which affects the amount you recover in a personal injury action. Most personal injury actions in Indiana are covered by the Indiana Comparative Fault Act. What does that mean? In January 1985, the legislature enacted this law to reduce the harsh effect of the prior standard for recovery. When two or more entities are involved and injuries occur, the fault is apportioned between the parties. Any fault on the part of the injured party reduces their recovery proportionately. And if it's determined that you're more than 50% at fault, you receive no recovery. So this can be very complicated, a legal concept when you're trying to apply it. However, depending on your individual situation, the purpose of this video is just to introduce you to the concept of comparative fault and also to explain why so many personal injury attorneys say you need to have a consultation before giving any statement to an insurance company. First, in an auto accident, you need to be aware that the police report itself cannot be used to determine who is at fault. Why? Because the police officer was not present at the scene and they're only reporting what they were told. The report can be a helpful starting point, but the insurance company for the other driver will want to take your statement. And they'll want to take your statement because they want to find a way to unwittingly cause you to say something that will allow them to assign fault to you. Let's take an example. Suppose you're driving through an intersection on a yellow light and someone turns in front of you. The police report will usually assign all fault to the other driver for failure to yield the right-of-way. But if you give a statement to the insurance company, and also depending on a lot of other factors, you could be assigned fault. In fact, you could be assigned so much fault that you would not obtain a recovery. A second common example is a multi-car rear-end collision, where the statements among the different drivers involved in the collision differ. For example, regarding whether you first rear-ended the car in front of you or you were pushed into that car by the car behind you rear-ending you. Or, for example, sometimes a police officer will assign fault even to the car that was pushed into the car in front of them simply because they say you were following too closely. A lot of people think that they can give a statement to the insurance company adjuster without any problem because after all you know what happened. But consider the fact that the insurance company adjuster spent a lot of time in training and has had a lot of experience in how to take these statements, and they work for the insurance company. They don't work for you. Their purpose is not to help you, but to see if they can reduce what their insurance company has to pay to you. So this concludes the video on comparative fault in Indiana. Thank you for joining me.